I was born into a cult, Satanic ritual abuse. It's a satanic cult which happens in the town of Riverdale.
Incest, violent sexual abuse, an evil group meeting in the woods to assault young girls. This is all part of a shocking lawsuit filed by a woman against her own father, who happens, by the way, to be a chief of police in New Jersey. And she claims the memories of her abuse came flooding back in recent years. But her father argues that her claims are completely baseless, and instead are ammunition in an ongoing divorce battle. We are going to try to parse it all out and try to sort it all out for you right now. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Real quick, before we get into all this, I want to tell you about something exciting that's happening here at Law&Crime. So we've partnered with On Patrol Live and Reels to launch a YouTube channel. Now, if you're unfamiliar with On Patrol Live, I'll tell you what, you're missing out. Dan Abrams, he hosts it. It is one of the best shows on the Reels channel, Reels Plus app, because every Friday and Saturday night, they follow police officers across the country in high-stakes ride-alongs with over 50 cameras rolling live. It captures all these actions in real time. And as you can imagine, the incidents caught on camera are quite wild, from high-speed chases to daring rescues to intense standoffs, everything in between. It just never stops. So head on over to On Patrol Live's YouTube channel. Make sure to subscribe. That channel link is in the description, and the channel officially launches today, July 14th. Trust me, you will not want to miss it.
My dad and my neighbor were two different types of psychopaths. My neighbor was an alcoholic who just had no mercy, just wanted to beat kids, rape them, assault them. And my dad was a very strategical thinker of how he was going about this, what he was doing, how he's going to do it. It's an organized crime.
That is Courtney Tamagny, and she's talking about the alleged abuse that she claims she suffered at the hands of her own father and neighbor for more than a decade. Now, Courtney recently appeared on the podcast We're All Insane to give insight into this bombshell lawsuit that she filed against not only her alleged abusers, but also the state of New Jersey and the state's Department of Children and Families. So we're talking about Courtney's father. This is John Scott Tamagny, who goes by his middle name, and his neighbor Keith Slevin. They have adamantly denied everything that Courtney has said, saying it is all completely made up, that this lawsuit is causing them huge problems. And before we even dive into the lawsuit itself, I have to give you a background about this. I have to set the stage, give you an idea of just who everyone is that's involved in this drama. So you have 20-year-old Courtney. She's the main plaintiff, and she claims that her father, Scott, started abusing her when she was just 3 or 4 years old, and claimed the abuse continued until she was 15. Now, in an amended complaint, Courtney's mom, Jean Tamagny, was added as a second plaintiff, and she has supported her daughter through her journey with psychologists and other medical professionals. This is, again, according to the lawsuit. In a response that was filed with the court, Scott says that he and Jean, they were married for almost 22 years, and that their ongoing divorce battle has been very contentious. So that kind of adds another flavor to all this. Now, Scott has been a police officer for years. He is now the police chief in Leonia, New Jersey. Hopefully I'm pronouncing that correctly. Courtney has two sisters, one older, one younger. The older is identified as Sarah. The younger, who was 17 when the complaint was filed in January of 2025, is known by her initials MT. And Courtney claims that all three of them were abused. In her interview with the We're All Insane podcast, Courtney mentions a younger brother as well, but he's not talked about in the lawsuit. So the lawsuit does name several New Jersey agencies, including the Division of Child Protection and Permanency, also known as the DCPP, which is part of the New Jersey Department of Children and Families, or DCF, the Bergen County Prosecutor's Office, and the state of New Jersey itself. And as for individuals named, as for the second amended complaint, there's John Scott Tamagny, Courtney's dad, Keith Slevin, the neighbor, Commissioner of DCF, Christine Norbert-Beyer, Joanna Holata, a DCPP investigator, and Sergeant Matthew Sablocki, an investigator for the Bergen County Prosecutor's Office. But Slevin has actually filed a counterclaim against Courtney for defamation, which we'll get into in just a moment. Hey everybody, this is another Law&Crime legal alert. Did you know that children are being diagnosed with serious conditions like type 2 diabetes and non-alcoholic fatty liver disease, and the research is potentially linking ultra-processed food to all this? Yeah, well here's the thing, Morgan & Morgan, they're stepping in to fight to hold these food companies accountable. With decades of experience fighting large corporations, they are ready to stand up for the families who deserve justice. So if your child under 21 has been diagnosed with type 2 diabetes or fatty liver disease, then visit www.forthepeople.com/food or scan the QR code on screen to learn more. Now I want to talk about these very, very serious allegations that Courtney is making in the official court record. So to do that, I want to welcome on criminal defense attorney Mike Koribanics, who I'm shocked to say has never been on Sidebar before, and let alone in studio.
But I started out near Sidebar with you years ago.
I know. Well, good to see you. Thanks for coming in. I appreciate it. Now, before we get started, I want to note that there are no criminal charges that have ever been filed against Scott or Slevin relating to any sort of sexual abuse or assault. These are just the claims that Courtney is making in this lawsuit, and that's what I want to talk about. So the complaint starts out like this, quote, plaintiff Courtney Tamagny brings claims for sexual abuse and failure to protect, depriving her of her constitutional due process rights, her fundamental right to be parented, her right to be free from government conspiracy with private actors to deprive her of her rights. Plaintiff Jean Tamagny brings claims for failure to protect, depriving her of her constitutional due process rights, her fundamental right to parent, her right to be free from government conspiracy with private actors to deprive her of her rights. And the two women are suing under 12 different causes of action. So what do we have? Violation of civil rights and 14th Amendment right to parent and familial association, conspiracy to violate defendant's civil rights and 14th Amendment right to parent and familial association, violation of civil rights under due process and equal protection, conspiracy to violate civil rights under due process and equal protection, assault and battery, incestuous abuse, intentional infliction of emotional distress, negligent infliction of emotional distress, breach of parental duty, false imprisonment, invasion of privacy, and transportation of minors to engage in illicit sexual conduct. There's a lot there, Mike. Which one of those stand out to you, or do they all stand out to you?
Well, they all stand out to me because they seem very unusual, because accordingly, but it hasn't been confirmed, there was full investigations into this by the criminal aspect of it, not the civil. This is a civil suit, so there's not as much there right now, but in the sense of an investigation, is probably still ongoing.
How much does that affect it? Because you know that there's a different, you can have a criminal case have one result and a civil case have a different result. The burden of proof is different. It doesn't necessarily preclude or bar her from bringing a lawsuit, right?
No, not at all. I mean, it's beyond a reasonable doubt for a criminal case, and it's just a preponderance of the evidence, which is like over 50% of the evidence in their favor. So this is mostly it's privately brought in a civil case, as opposed to, accordingly, there was investigations here by the prosecutor's office and all these other state panels, and there was no bringing of a criminal case.
What do you make of the alleged violations of constitutional rights or due process rights or parental rights? How does that typically work in a case like this? I mean, I can't say I've seen too many lawsuits from a child against the parents, but those are really interesting legal claims.
Yes, they are, and they're very, very intricate in the fact that they're, like you said, they're not much you hear about all the time, and they're very specific into the allegations that are made there. But I also believe if there was a full investigation by the government, it's much more difficult to bring those kind of claims against the government. However, as to the individuals, you just don't have the higher standard of proof, so it's easier civilly than criminally.
And it's interesting when you look at like intentional infliction of emotional distress or negligence. Sometimes those are, overarching kind of claims that can include a lot of different conduct or alleged conduct. So according to Courtney, her father, Scott, now we're going to get into the allegations, came into her room one night when she was very young, around ages 3 or 4, and assaulted her in her bed. And she says her mother was out of town. She claims the abuse continued, with Scott allegedly cornering her in the shower of the home's basement. According to the lawsuit, quote, defendant father threatened to beat plaintiff Courtney Tamagny and MT if they told anyone. Plaintiff Courtney Tamagny has specific recall of MT crying a lot. MT told plaintiff Courtney Tamagny what he would do with her in the shower, and plaintiff Courtney Tamagny believes her because he did the same thing to plaintiff Courtney Tamagny. Plaintiff Courtney Tamagny has recollection of defendant father forcing her and her sisters to take pills which would cause her to get dizzy and then lose consciousness. Plaintiff Courtney Tamagny recalls defendant father giving her an empty orange juice before bedtime and giving them pills, or sometimes putting pills into the juice. Defendant father also threatened to kill their mother, plaintiff Jean Tamagny, if plaintiff Courtney Tamagny told anyone of these events. I mean, Mike, these are disgusting, serious allegations. And I think on one hand, you wonder, would a daughter, just make all of this up against her father unless there was something here? He hasn't been found liable. He's entitled to a defense. But at the same time, if she goes on the stand, if this is allowed to proceed to trial and survives, let's say, a motion to dismiss, and she just recounts that, and there might not be documentary proof, text messages, videos, anything like that. If she says, I will explain to you what happened, when I was a child. Can that be enough to secure her a win in front of a jury?
You know, Jesse, as you bring that up, it shows how it seems simple, but when you think about it, it's very complicated.
Right.
Because there's no proof of something that happened when you're 4 or 5 years old, and we're over 20 years later, or close to 20 years later. So it's really just going to be that testimony, unless the father has something to bring against it, which is something that it just seems it's going to be one word against another.
Well, what happens if the mother's supporting her? Does that help?
Well, it only helps if she could support her by confirming what she's saying. So if there was something where she was away, that'll confirm she was away, but as far as whatever actions happened while she was away, she can't testify to.
Well, at some point, the family moved homes. So they were going from Tenafly, New Jersey to Rivervale, and that's when Slevin, this neighbor, allegedly entered the picture as a co-abuser, because the lawsuit reads, quote, plaintiff Courtney Tamagny has specific recall that defendant Slevin was obsessed with plaintiff Courtney Tamagny and had alcohol on his breath. He physically struck plaintiff Courtney Tamagny and had intercourse with her. And then the story takes another turn, with Courtney saying she was raped in the woods as part of some sort of alleged cult. So from the complaint, it says defendant Slevin and defendant father would take the plaintiff Courtney Tamagny and her sisters, MT and Sarah, into the woods in Rockland County, New York, and there was what appeared to be other middle-aged men present with masks on their faces. She recalls there being fire and animals being burned, and they would chant as if ritualistic. She didn't understand what was being chanted and closed her eyes in avoidance. She was sexually abused in those woods by defendant Slevin, defendant father, and some of the other men present. She recalls MT being struck and seeing MT not being able to run away from the men and being hit multiple times. On the We're All Insane podcast, Courtney told the host that the men in the woods would make the sisters participate in these sick games like hide and seek, where adults would try to find them to harm them. She also described drum circles and animals and people being burned in tunnels that allegedly connected different places where abuse had occurred. Now, Mike, you know, these are very wild allegations, but at the same time, is it possible someone could just make all of this up? Or, again, to make a lawsuit like this public, to make these allegations, to put your credibility at issue, to go after your own father and name certain people, you have to wonder whether or not this is credible. But it is quite an allegation.
It is quite an allegation, and you have to wonder if it's credible because of the fact that this person, she has gone under some mental health issues. But another thing that's a little interesting in fact of how it goes to the proof is the fact that she's including a neighbor. So you would wonder if she was just making it up. Why would you include a neighbor, just go after your father or something like that?
So I'm saying it adds to the credibility, perhaps.
Perhaps, or it just adds to the need to further investigate it by both sides.
By the way, from a point of view, if she presents this case to a lawyer and says, I want you to file this lawsuit, what is the job of the lawyer to validate those claims at the beginning of a lawsuit, right? I mean, obviously there's going to be discovery, you'll get information from the other side, but should a lawyer just take any case, or do they have a duty to investigate it before they file it?
Well, I don't believe a lawyer should take any case. You should have to have some, you have some ethical obligations to see if there's credibility to move forward. We can't predict where it's going to go, but you need to look at it and say, is there something here that could lead to further investigations and things of that nature? So there has to be some credibility. Doesn't necessarily mean there is, because some lawyers just will take any case, but you need some credibility to file it.
And this is important to know too. So Courtney claims that she suppressed these memories of her sexual abuse, but allegedly had health problems and eventually saw a doctor for it. Quote, the recall of abuse was released when plaintiff Courtney Tamagny was suffering vaginal pain and examined by a doctor who made inquiry about sexual abuse. Plaintiff Courtney Tamagny realized she had been blocking the memory of the abuse, and recall of the abuse started coming back to her. She realized that she had been suppressing the recall of the abuse for years. Courtney says that she started seeing a therapist, and that the therapist then reached out to the Division of Child Protection and Permanency within the DCF. Quote, on February 7th, 2022, a referral was made by plaintiff Courtney Tamagny's therapist to the defendant DCPP about sexual abuse by the defendant father to plaintiff Courtney Tamagny. Plaintiff Courtney Tamagny, then age 17, shared her recalls with her therapist, and a report was made. But Courtney claims she wasn't taken seriously, and that DCF didn't do a proper investigation. Quote, the investigations conducted by defendant's Bergen County Prosecutor's Office, DCPP, DCF, and State of New Jersey, and defendant Holota, including the interviews of the children, were conducted in such a manner as to deprive the plaintiff Courtney Tamagny and her siblings and plaintiff Jean Tamagny of due process and the rights to be free from harassment, and should have been conducted, but were not, by specialized trained professionals with experience in forensic interviews of minor children on the subject matter of sexual abuse. What do you take away from that, Mike?
I find that not to be very credible, quite frankly, because, you know, I'm a former prosecutor. I'm familiar with the Bergen County Prosecutor's Office and all the prosecutor's offices in the state of New Jersey. And to say that they didn't do an investigation or
a proper investigation
is very difficult, because every prosecutor's office has a child victim sex crimes unit. They have a sex crimes unit that specializes in that to go further and to do investigations. So I think that's, while it may be an allegation, I think it's a difficult allegation to back up. If in fact it was reported to them and reported properly, I'm sure they did an investigation. And also, we got to also look at the fact her father was chief of police in Leonia.
Well, doesn't that work for her benefit? Like, couldn't she make the argument there was a cover-up to protect him?
That's always an argument that could be made, but I also think there's also an argument to be made for the other side of the investigation, saying what prosecutor's office is going to want to allow someone to be a chief of police if he's violating these sexual kind of things.
That's 100% true.
And this is something where if you're doing this, you have some mental disability.
Let me ask you this. Is it possible that there's a gray area where there was an investigation, but they looked into it and they couldn't corroborate anything, and Courtney and her mother are just dissatisfied with the results, and maybe there's not an appreciation for what was required or was not required for such an investigation, and they might just be dissatisfied that there was nothing further and there's really nothing there for them to sue on. I mean, that's a possibility too.
I think that's a strong possibility. I
Okay.
think that's a good point. Because two is just because it didn't reach a criminal standard to go further, there's a less standard in the civil case. So that's up to them what they want to do. And you're also not having anybody other than your lawyer really verifying if you have a good way to go forward.
Let me add something to this. So Courtney had claimed to have flown down to Florida with her older sister, Sarah, to be examined by a Dr. Stephen N. Gold. So as part of his assessment, he wrote, according to the lawsuit, in conclusion, it is my professional opinion to a reasonable degree of psychological certainty that the abuse described by CT and ST occurred. Their accounts are highly consistent with both the psychological research literature on childhood sexual abuse and my own clinical experience assessing and treating hundreds of adult survivors of childhood abuse over the last 4 decades. In addition, it is my professional opinion that to place MT in her father's custody would put her at serious risk for abuse, and that to force MT to participate reunification at this point in time, even under supervision, would in all likelihood backfire, fostering antipathy and diminishing the likelihood of MT establishing an amicable relationship with her father once she reaches adulthood. And another well-known child abuse pediatrician, Dr. Randall C. Alexander, reportedly agreed with Dr. Gold's analysis, according to the complaint, and the lawsuit went on to list out the harm that Courtney has suffered because of her father and Slevin's alleged abuse. And this list is quite long, but it includes everything from severe mental anguish and loss of capacity for enjoyment of life to eating disorders, nightmares, PTSD, fears of intimacy, sexual contact, and her suit doesn't list a dollar amount that she's seeking, but instead requests appropriate damages. Let's start there. So, Mike, you list out everything you suffered for the purposes of the harm element and for damages. What could that escalate to if a jury believes this?
Well, that could be really unpredictable and extremely high, because of the fact is, you know, a human being is developing in their world, and a father who's responsible for that is abusing their own child. It's bad enough to abuse someone who's not your child, but to abuse your own child who you've basically made a promise to take care of and to just use for your own self-gratification is rather scary.
Well, if you have now the backing of these psychological experts, you're already looking at, these are key witnesses at a trial, right? I mean, but from a defense perspective, how would you cross-examine them?
Well, first thing you want to ask them is how much they got paid.
Right.
Because you want to see, are they doing this? It's a little different. That's why it's a lot different in a criminal case, because in a criminal case, the investigation's from the government, and they're not getting paid more or less as to what they're doing. Here, your argument would be is, well, didn't you do that so you could just keep charging them to come for therapy and all these sessions and things of that
And you can look
nature?
at their past cases too.
Absolutely, and see how many times they've actually testified in court. And if they do that a lot, that works both ways, because the plaintiff would argue, yeah, they do it a lot because they're good at what they do. And the defense will be arguing that, well, they do it a lot because that's how they're getting paid and making money.
So now how are Scott and Slevin responding to all of this? Okay, well, Scott filed a motion to dismiss with the court, saying that all of this is part of a smear campaign against him because of this ongoing bitter divorce and custody battle that's lasted years. And the motion points out that while Courtney makes broad statements about alleged abuse, she doesn't provide specific enough examples. And he says the claims just aren't plausible and they don't meet the burden to file a lawsuit like this, right? So you and I both know from the beginning of law school, right? It has to meet, there's a bare minimum a lawsuit has to meet. You can't, in other words, even if you accept everything is true in a complaint, does it meet the criteria for the elements of the causes of action? You can't just make generalized statements. There has to be some degree of specificity, right?
Yes, absolutely. But in this case, it may be a little bit more approachable for them because of the fact that she was going through some mental health issues. She was a child at the point in time.
That's the point.
And that she didn't really recall it till she went to therapy again. And there's going to be very interesting as to what the mental therapist says about that, and basically saying because she was so abused, she blocked it out.
It's interesting you say that because this motion also objects to Dr. Gold's assessment, agreeing that yes, Courtney and Sarah went to Florida to meet with him for several hours, but he didn't do any sort of examination himself. When he gave the analysis included in Courtney's lawsuit, Dr. Gold allegedly hadn't fully gone over the women's therapy notes or spoken with their doctors. And according to Scott's motion, Dr. Gold wrote, "It is not possible for an assessment such as this to categorically conclude whether or not child sexual abuse occurred." Well, there you go. That's how they were going to defend it.
That's a pretty strong defense, because you would say, why wouldn't you evaluate prior people who evaluated this person to see where they're going? But I guess the argument on the other side would be is, I'm the professional doing it. I want to make sure what's going on, and I don't want to rely on what somebody else did because I don't know how accurate that is.
Now, the Department of Children and Families, they also filed a motion to dismiss, citing sovereign immunity from the federal government, interfering with state court determinations related to custody, as well as qualified immunity for Bayer and Halota. The DCF motion also notes the basis of plaintiffs' constitutional claims relate to an alleged inadequate child abuse investigation. However, there is no recognized constitutional right to an adequate investigation. Are they right?
I'm not extremely familiar with that, but you have to have a point of immunity, because you shouldn't have someone prosecuting a criminal case with all these constitutional rights because they're worried that if they don't do it, they're going to get in trouble. So you need to have that sort of freedom in your evaluation.
Yeah, and then, by the way, Keith Slevin filed a request with the court that he be allowed to proceed under a pseudonym. The motion states KS is a professional who may experience a great deal of harassment, adverse employment action, as well as danger to his person and well-being if his name is not removed from the complaint. The judge actually denied that motion on June 12th because, generally speaking, is it hard to ask for a pseudonym, or is it like your name's already out there? I don't know.
Well, it's a public record. Your name's already out there. There's obviously already shown some level of proof that this is a valid complaint. Whether it gets dismissed or not, you don't know. But look at this. That's why we're here most of the time, is because the names are released of the people who are important or the people who are public recognized.
And he also filed a counterclaim, writing, Keith Slevin has been exposed to public ridicule and held in disrepute among counterclaimant's professional colleagues and clients, causing counterclaimant to suffer extreme embarrassment and humiliation and severe mental distress, all to counterclaimant's damage. So he's suing for many of his own claims against both Courtney and her mother, including malicious abuse of power, defamation, malicious prosecution, false light, intentional infliction of emotional distress, negligent infliction of emotional distress, and harassment. And in a statement, Kevin Korston, Slevin's attorney, told the New York Post, it's made up out of whole cloth. This entire complaint was previously investigated by everybody from Homeland Security to the Attorney General's office in New Jersey to the Bergen County Prosecutor's office, and they found no basis at all for these outrageous allegations. Having got no satisfaction from law enforcement, she now decided to sue all the people who were involved in the investigation. These claims are on their face unbelievable. There was no way in this world that there was some sort of secret satanic child sex cult operating out of Riverdale, New Jersey. By the way, we think Corson actually meant to say Rivervale instead of Riverdale, just pointing it out. This is a fantasy made up in her mind. Scott's attorney also shared similar statements saying the allegations are completely false and defamatory, and the case is now moving forward right now in federal court. Real quick before we wrap things up, I can understand filing counterclaims. However, for defamation, typically speaking, you can't really file a claim for what somebody alleges in a lawsuit, unless everybody would file a claim for defamation. Is it only for statements she made outside of the lawsuit, for example, on a podcast? Is that what you could file defamation for?
I believe so, but it also could, we'd have to see how accurate it is when they're saying it in the courtroom, because if you're saying something that's totally a lie under oath, you're violating the law.
All right. Will be interesting to see what happens. It's just quite an allegation, quite a series of disturbing accusations. But Mike Koribanics, good to see you. Thanks for coming in.
Thanks for having me. Always a pleasure, Jesse.
And that's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.